Striking 3.
Yeah, with the agreement of the official.
Which one is being stricken?
C.
Point C under list of regarding the item.
7.
Maybe you see you have sheet on the very bottom page of the front page. Yeah, this started early too, I forget. It's 10 o'clock. So the committee recommends, in the first place, that Judge Arnold be investigated for impeachment for offending the dignity and undermining the integrity of the courts and the confidence of the people, failing to uphold the laws of the state of New Hampshire, for infringing the natural and constitutional rights of the petitioner in various ways. There's one of the points that comes up, we'll just discuss this point, but one of the questions that comes up is this question of patterns of behavior. Are we looking for patterns, or as a single event, or a series of things in a single situation enough? And that's the only point that I would make. We've discussed that question of pattern before. I am here for, this point is available for discussion. And further discussion on this point.
Mr. Chair, has Judge Arnold come, thank you, Mr. Chair. Has Judge Arnold come up in any of the other petitions that have been before us?
Judge Arnold has come up in so many categories and quiet conversations on the side that I can't remember. But Judge Arnold is always a little recorded, which Thomas Ball had his reactions, shall we say. He's tragic, playing out of objection to his behavior. So I believe that was, if I remember reading it, I think correctly, it was directly related to Judge Arnold. I'm not telling you that's a pattern. It's just, I mean, it's a pattern, it's a generalized pattern, but it's. I'm not convinced it's needed, and I only say this for that reason. There's enough in this particular case that I'm not convinced we're a pattern. This is a pattern. There's a pattern of law breaking in this case. So is that a pattern? If you do, one time in the middle of a case, he screws up, and he doesn't routinely do it through the rest of the case. But the idea that a person could actually never hold a hearing to allow a GAO
Or waive
to have appointments. And go on and on, waive orders without any actual waiving of orders. I mean, this is just so lawless. It's just outrageous.
Just to follow up.
I don't know if it, and there's a pattern of it. So I'm working on this just as a regular conversation, regular.
As a follow-up,
For
for dereliction of following and waiving court or administrative orders by the Supreme Court, isn't that grounds enough for an investigation or an impeachment right there in itself? I mean, it's not accidental.
Right, and you make a very good point about the accidentalness of these things. If we actually saw that he was doing these things, it was corrected when a motion was made, by a lawyer, certain. But the idea also of enough of them in this one case do suggest the need for investigation, which would put it to the pattern that exists.
May I make
this is my point. No, it is necessary between us for now. No, don't fail to put your hand up from time to time if you want. I think I've represented the party first and on with
well, I mean, I'm probably not going to vote for any of this, but Justice Arnold, certainly that was one of the requests of the original petition was to consider impeachment of said Superior Court Justice, which was Arnold, and we could certainly within our powers to recommend impeachment of a Superior Court judge, and certainly within the legislature's power to try for impeachment, and I suppose you could do it from one particularly egregious case. This may be politically difficult because this hasn't even been appealed to the Supreme Court for other reasons. So that's well within our powers, and I don't think Judge Arnold has been specifically mentioned in any other petitions, but I believe this is the only petition that involves a case in the Cheshire County Superior Court. So that may just be
at this point. Yeah, Representative Lambert and then following Captain. Captain.
Should that not say who we wanted to do the investigation?
The committee should recommend that the House. That's what you're saying.
Well, either the House or
well, the House
does
initiate
Attorney General or somebody.
No, the House. Yeah.
Should say so.
That's correct. You're right. That's point well taken. That would be correct when you say that the House. And it would say something to the effect that the House begin
say be investigated by the House for impeachment.
Right. That's right. Representative,
I just got a question to that. Can the House do that without a formal bill put in?
the House does an investigation of impeachment as a bill.
Right,
It's
so
a
it
bill.
would have to be a
It's
bill,
an
would
investigation.
have to be, a legislation would have to be submitted.
So would you want to phrase that way? That'd be probably more correct to bring in legislation. I'm not sure
It's
it's
like the
necessary.
investigation.
Yeah, I'm not sure it's necessary to say it that way, but yeah. I was just making one of several points that that's a Representative Lambert, I believe you're back up. Was I?
I don't have my hand up until
Oh.
point two, but at
Okay,
point
okay.
two,
Wait a second.
back in the game.
Anything else, point one? Representative Morgan? Yes.
I don't have the HR, I guess it was HR 27 when they were considering impeaching Master Cross and a number of others earlier this millennium. So I think, I don't have that, I don't have the results of that report, but that's exactly how they phrased it. But I mean, investigations would be part of it. I think what happened in that case was, the House Judiciary Committee sort of discussed whether there's anything worth investigating, and Chairman, the consensus in that committee that it wasn't worth pursuing for that particular case, but we did. I suppose that is probably good terminology there. We would have,
It's a House resolution, we agree, yeah.
I think we would have had to, like, I think we would have had to, like, pay for how, I recall, I think the procedure was, I think we'd have to get a counsel for the, we'd have to appoint a counsel to serve as a prosecutor, in the sense that we'd have to collect the evidence and then also, we'd have to pay for an attorney attorneys for Justice Arnold, who's going to defend himself. And we would eventually at some point then have a trial in the House, or we would be like a grand jury in the House, and then the Senate would serve as the trial if it passed the House.
So that, if we agree with the concept here, that can be phrased according to what is now followed. The idea we suggest a House resolution that the committee recommends the House resolution be brought to. And then, further on point one?
Well, to say there is a well-established procedure for it, and so that's certainly within our knowledge.
Right.
Whether that's likely to get anywhere next year is another question, but that's, whether it's still here next year.
So then on point two, see no further discussion.
May I make a-
Make a point to us? I think the committee's always appreciative of that.
And that refers to, again, the very bottom C under 7. Point of Representative Lambert, I think that's correct. Can't be a prosecution because of the immunity that's been granted to guardians of life.
We take that.
But I think what could be stated, the committee finds this, that because Ms. Hamilton's actions were.
Pause for a second. He's asking us to back up to before the recommendation started, in that last point where I was following that suggestion of Representative Lambert that we strike C in the very last paragraph there. And so your point, so it should, there might be a better way of saying it, or
Well, some kind of language that Judith Hamilton would rightfully be criminally prosecuted for these acts were it not for the grant of immunity provided by the Supreme Court to guardians ad litem.
Okay. Would that be a
Something like
problem?
that.
Would that be a problem with you, Representative Lambert? That makes sense to me.
Makes sense to me.
All right.
I think it's good because it shows the dynamic of what's going on.
That's actually the intent of this. Were it not for immunity, and that's an important thing before we get to recommendations. So that phrase is very clear that, what would be there would be stay there, but the words were not for the immunity, et cetera,
Right.
would be the lead line.
And that refers back to recommendation 2, which would go into the draft or legislation that would override that grant of immunity to guardians ad litem.
So obviously 2 is yes, where Representative Lambert would again make his point. They aren't going to do it. And therefore, what should that look like? We should actually talk about drafting legislation that would make them take away the immunity again. Does that show up in here though, actually?
No, it's not.
It doesn't show up in here at all, does it?
Mr. Chairman,
It does show up in a different petition.
didn't we,
Representative?
thank you, Mr. Chairman. Didn't we, in the Dow case, find, according to recommendations from Representative make recommendations that we would submit statute to
Yes,
remove.
that is where, yeah, that is where I read it recently. Yeah,
Yes.
that's right.
So that is in the fireworks, I guess.
So we'll strike 2 as such then, is that correct? That obviously, this isn't something we're gonna recommend since they're not gonna do it anyway. But instead, we're going to recommend, what is the phrasing in the Dow petition? Recommend that we remove the immunity. I believe we may have said something like required to be bonded or something like that.
Yes, you have it in here somewhere else, I think.
Really?
Yes, under C, eliminating, there it is, it's already here.
Oh, it's already here, so we're just
Eliminating
writing to
immunity
period. Okay, good. I
Yeah,
thought so.
requiring the formally trained and bonded.
All right, so let's just jump, we're gonna renumber now, we're jumping killing 2 and renumbering 3 as 2, and we're gonna, now, so I'm gonna go ahead and read this book, like any other discussion. Draft and pass legislation, and so A is required that rules of evidence, procedure, and all other rules of the pertinent courts be complied with by judicial courts. This is poorly phrased, I think, or at least clumsily, long phrasing for making statutory the rules. Am I not saying that right? Making it so the abiding by rules is statutory? And I think I would rephrase it to that effect, for example.
I just think we should remove the word pass legislation. I don't think we can pass it. I think introduce we can.
Why don't we say the word introduce and take away draft and pass? Introduce is the right phrase. I agree with that. Is there any problem with that?
Yeah, introduce is better.
Introduce legislation, all right, requiring that, why don't we just say instead of requiring, why don't we say making the rules,
You can just leave that word out.
What
Because
word?
draft legislation, A, that rules of evidence, just go on. You won't need requiring that, just that rules of evidence. will go on.
introducing legislation, oh, right, I see your point, yeah. Right, that's a good point as well, yeah. That rules of evidence procedure always be complied with. So the word statutory has to get in there, so the
Yeah.
concept, we understand it, you understand it, I understand it, it has to be rewritten, but I'm going to probably move this anyway.
The
We
rules be
understand it.
statutorily mandatory, statutorily mandated, or,
Be statutory, yeah, well,
That's
it's clear what we're doing. Yeah, we're going to make it so the rules must be abided by as if there were statutes. Is that what you're
Yes.
saying? Yeah.
same good.
All right, and B in that was requiring that all motions and petitions brought before a court and have to be docketed immediately and scheduled to be heard within 6 months after document. Any discussion of that point B? Is that doable? I mean, can you actually docket immediately? I mean, don't they have to go and?
That's what they do in every state, investigating.
Oh, really?
It's normal.
That-
You walk up, you give them a petition, they have a computer, they say, oh, we have the
Opening
first
hearing.
time we can hear is, I don't know, August 4th at 5 o'clock, 4 o'clock.
I'm going to eliminate some politics.
Yes.
Yeah. Any further discussion? C then, eliminating immunity of guardians ad litem, requiring them to be formally trained and bonded, and requiring that an accounting of the public input provided at the GAL audit hearings be included in their recent report. That's a little random, not throwing that on at the end there.
Didn't one of the previous recommendations, and one of the previous recommendations that's already left this committee, didn't it say that you were gonna abolish the GAL altogether? Recommending you abolish the GAL?
I don't think so. I don't think so.
Sorry, Mr. Chair, but I think you.
Representative Avery?
We were talking about the immunity, abolishing the immunity. of this statute.
All right.
Yeah, no, I'm sure we didn't, actually, that discussion came up a number of times though, because of the energy to do that. And it's a long-standing need, like, for example, older people that are in need of somebody protecting their health or something like that, when they're home, or whatever, so you don't just throw it out, you have to make, we found that.
All right.
A lot of good discussion on that.